at the Tel Aviv Magistrates Court. In the matter, Radley Nina 038403937. For 298401 radleyaudit@gmail.com, radleyaudit@gmail.com, 0549521810. The plaintiff, NGD. ADV Arik Mevarak 80, King George Street, Tel Aviv, by email Eric at mevarak-law.com, telephone 052-553-2222, landline 03-5280450, fax 03-5280450. The defendant. Type of claim and subject matter: civil monetary claim, requested relief amount of claim, $2,231,901 NIS. Fee, $55,798 additional proceeding in court. If there was an additional proceeding in court or tribunal in connection with a similar set of facts to which the plaintiff is a party. The lawsuit is based on a disclosure in the only hearing in the legal case 25135-06-24 Radley v. and the Custodian General versus Stan and Oded. There, the defendant, Attorney Arik, admitted of his involvement in criminal ACT. A list of all the remedies requested and the value of the subject of the claim. To oblige the defendant to pay the plaintiff a refund of the amount of theft, oppression, and compensation in the sum of $2,231,901. Disclosure of assets. To compel you Bank Rothschild branch to present banking information against the background of the illegal activity that took place in the account of the deceased, the late Hannah Radley, 0125043004. Mr. Mevarak withheld this information from the plaintiff when she negotiated the cancellation of a will to manage a trust towards her by her brothers, one, Dan Radley, an adopted brother, originally a Muslim alcoholic and a failed gambler for many years, and the other a bank brother, Oded Radley, pampered and hedonistic, who lives at the expense of women. The eldest left behind a chain of friends or dead or brain damage due to drug poisoning that he initiated. He closed his wife by coercion of drugs once, but because she found romance there. In 2020, he crumbled her with benzodiazepine food and stole 100,000 shekels from her tax returns. The plaintiff was forced to do so in 2015 to 2016. She walked around mute. In 2020, he crumbled her with benzodiazepine. The plaintiff also was poisoned, became mute, and only in February was she able to communicate with the doctor that she did not want any pills and that pills would not be forced on her. The fact that the brothers buried her, contrary to her command for donation cards and her request for an autopsy at Tel Aviv University, is under police investigation. For 99808-2024 summons to trial, Civil Procedure Regulations 5779 to 2018 First Addendum. Type of claim: civil monetary claim. Since Fardali Nina has filed the statement of claim against you, you're invited to file a statement of defense within 60 days of being served on you with this summons. Please note that if you do not file a statement of defense, then according to Regulation 130 of the Civil Procedure Regulations, 5779 to 2018, the plaintiff will have the right to receive a judgment in absentia. Part 2. 1A. Concise description of the parties. 1.1. The plaintiff, the daughter of the deceased, Redley Hannah, for whom Mr. Meverak executed an illegal power of attorney, is a citizen of England and Israel during her military service with the Cabin 96. She chose to be a boys' trainer and fitness instructor. She was trained as a pool lifeguard in an IDF course. She has a degree with honors in psychology. She is a pool lifeguard and a fitness instructor in the Israel Police. Graduated with honors from the Ministry of Law exams in accounting and tax consulting, and has passed multiple related financial certifications, including accounting, MCTS, retirement consulting. Owner of a small business since 2008 and an employee. Formerly a financial manager for 5 years in a subsidiary of the Israel Electric Corporation, a member of the world's #1 accounting firm. He identifies as a parent. 1.2. The defendant is a lawyer. Apparently out of religious anti-Zionist motives, he chose not to serve in the IDF or to cease service. He advertised himself electronically as a real estate lawyer. But at the same time, he was registered with the bar as an enduring power of attorney. This document is intended to protect the rights of disadvantaged populations. Against the will of the deceased, she was expelled from her home and took an active part in the attempt to sell the deceased's real estate while she was still alive. While in the background, he gave the couple of brothers legitimacy to operate for about 2 years without authorizations in the deceased's account, for their benefit and for his benefit. Registered with the Israel Bar Association as certified in an enduring power of attorney. As stated, a document intended to protect the rights of disadvantaged populations, but worked with all its might to make the mother and daughter homeless in order to end a real estate transaction that he had put together without their knowledge. He did not perform military service. Apparently, he belongs to a religious, anti-Zionist messianic stream. The Muslim brother in the original once sent me to meet the rabbi who was being paid money, and indeed the aforementioned demanded that I buy brochures, pay him, and refrain from producing a receipt for the payment. and it is possible that he himself lacked a certificate of books. Section 46. A kind of religious pyramid based on donations to a messianic rabbi without the supervision of the State of Israel, under the guise of Chabad. It is possible that the same lawyer is inspired by the aforementioned rabbi in preparing documents for the oppression of citizens to fill his pockets. Statement of claim. A statement of claim is hereby filed against the defendant, and the following are the reasons for the claim. Two, essence. 2.1 Mr. Meverack created an enduring power of attorney document for the elderly woman, Hannah Radley, without legal validity and as part of her deception. He was a partner in the disappearance of approximately NIS 6 million from her bank account, which the plaintiff did not know about, the loss of income and financial benefits that she had, and was also an active partner in finding a buyer for the house in which the elderly woman lived, while she was living while being expelled from it. Mr. Meverack apparently also created wills for her parents that the plaintiff did not know about. The wills were not signed by a lawyer, but Mr. Meverack stored the wills with him, without the plaintiff's knowledge, again while openly tarnishing the principles of the laws for the protection of the elderly and preventing their exploitation. When the mother died, the brothers revealed a will that they were documenting to steal from her using a trust account. The aforementioned was hired to conduct negotiations to divorce the plaintiff from the home in exchange for refraining from submitting the will to the registrar. During the negotiations, Mr. Meverack presented his involvement in the sale process, which began while the elderly woman was dying. The plaintiff conducted negotiations for which she paid NIS 55,000. Negotiations in which she agreed to leave the house, but Mr. Meverack and the pair of brothers sabotaged the negotiations because they did not agree to present what had happened for 2 years at their mother's bank. It is possible that he directed the couple of the authorized brothers to act in abusing their mother, while divorcing her from her home, separating her from her friends, from the plaintiff, and it is reasonable to assume that there was also medical negligence towards their mother. In addition, he directed severe and sabotage violence against the plaintiff. Violence that includes surprise attacks and chases while her lawyer was on the front lines for 300 days. The country was bombed and they decided to chase her in the premises. 2.1.1 Oppression and Theft. This lawsuit concerns Mr. Meverack's liability for creating an illegal enduring power of attorney for the deceased Rudley Hannah 0125043004 in the form of pre-estate. Actions of oppression and theft for his benefit and for the benefit of a couple of siblings. The power of attorney was used as a tool to pressure the elderly woman out of deception. The aforementioned was involved in directing a couple of brothers to take control of their mother's assets while she was still alive, on the basis of a forged document which Meverack created and the withdrawal of favors and cash for him and the pair of brothers. It was claimed that the defendant, a lawyer who joined Dan Radley, an adopted Muslim brother, had a criminal record in his youth for drug trafficking. An adopted man who grew up in an English-speaking home, who beat his mother and sister as a teenager and chose to carry out financial violence against the plaintiff and her mother with suspicions of attempted murder with the lawyer. Adopted, with an addiction to gambling in the capital market, who managed to become a failed real estate broker, but was unable to obtain a matriculation certificate and even learn to speak English to his parents. It was claimed that the defendant received favors from Dan Radley in joint real estate transactions, served as a colleague as a real estate lawyer. He apparently received over 1 million shekels in cash or other benefits from the brothers when they took over the elderly woman's bank account and credit card for 2 years and also after her death, when he directed the brothers to hide their actions and try to make the plaintiff homeless. Upon the death of the mother, the defendant explained to the pair of brothers that they had to dismantle the plaintiff's house, as well as drag her by force out of her premises when they revealed a will that they would manage a trust for her. After they sent saboteurs to the mother's death who walked at night, and after the beatings, she was exposed to the will, which she did not know about, and paid 55,000 shekels to the negotiating lawyers, in which Mr. Meverak was involved. This is a person who claims to have created a power of attorney for the mother, held a will for years in a drawer for the plaintiff, who apparently drafted and did not sign it, and also went and deposited the will with the registrar of inheritances. The youngster, a banker with the lowest degree in social sciences he bought from college, pretends to be a financial genius who, together with his eldest, gambler, destroyed the investment portfolio of his father, an accountant, in a celebration of gambling and the withdrawal of favors. Due to the fact that the lawyer tried to sell the deceased's house while she was alive and continued on the matter, he testifies that he was apparently promised a juicy commission and was apparently paid to break up the negotiations that took place in April 24th, while hiding financial information about theft from the deceased's bank since then. Even though the war broke out and Israel was bombed, he sent the brothers on bullying attempts to make them homeless again even during the war to carry out surprise attacks by arriving and chasing her. The fact that he continued in the middle of the war indicates that he was apparently promised a lawyer's commission from the sale of the residence. All of this adds up to a sum of 1 million. The pair of brothers are still depriving the plaintiff of information about transactions in her deceased mother's current account and credit cards. Receipt of cash/cash equivalents and or promises of a juicy share of real estate with the development that began there, about 20 million. 2.1.2 Creation of a legal document intended to protect and used as a tool of subterfuge. The defendant, a lawyer, advertises himself by electronic means as a real estate attorney. Since 21, he has been an active partner and facilitator in creating pressure on the elderly woman to give up her tangible and intangible financial assets. Over the course of 2 years, 6 million shekels disappeared from the deceased's bank. At the same time, he was involved in an attempt to sell her house. All this while acting in contravention of the laws and regulations relating to enduring power of attorney, relinquishing her place of residence, her liquid finances, deception, withholding financial information, and detaching her from the environmental and social system that surrounded her, separating her from her home, the plaintiff, who cared for her and was her best friend, while creating a deliberately traumatic set of conditions against the background of physical weakness, pressure to give up her territory, to give up her money and property without legal validity. In popular terms, it can be argued that he pushed her to her death. 2.1.3 An attempt to sell the elderly woman's home and violent terrorist activity. The lawyer was apparently also a partner in the creation of wills against the plaintiff, with the aim of selling the deceased's home. He was involved in negotiations to divorce the plaintiff from the house that her mother had built for her, refrained from disclosing 2 years of banking activity in the deceased's account during the sale attempt, sent the brothers to beat the plaintiff, directed the pair of brothers to send her emissaries at night, to walk around her premises, sending text messages with death threats, etc. Jurisdiction of the Tel Aviv District Magistrates Court, the substantive and local jurisdiction to hear the claim. Therefore, the Honorable Court is requested to summon the defendant to trial and to order as requested in this statement of claim. Part 3. 3. The facts. 3.1. On December 1st, 2024, the defendant claimed for the first time in court, in the case relating to the plaintiff's objection to the will, that they had created an enduring power of attorney for the deceased, which did not come into effect because the mother had passed away. This was the first time that the plaintiff had heard that such a document had been prepared, and for the first time she understood why the mother, who was sobbing that the pair of siblings had expelled her from her home and stolen her money. Clearing with the supervisor of the Administrator General, the document had no legal validity, as it was never given to the Administrator General and was not notified. 3.2. In addition, in 2021, probably the year in which Attorney Meverak signed the mother, the pair of brothers decided on their own to eradicate the rental income for the mother in Eilat. The mother had a fixed rental income in Eilat for about 20 years. In the 21 years the siblings turned the place into a vacation home only for them, they withdrew money from her account for the renovation of the place, and did not even grant their mother the right to use the place. In 21 and 22, the mother complained that they were withdrawing a lot of cash from the bank. In an affidavit of properties that the brothers made in court on the subject of the objection, the brothers claimed that the apartment was suddenly worth $400 million. This is unreasonable and apparently hides that the cash favors Mr. Meverak received. The betterment expenses were about 100,000 shekels. Invoices exist, and the area was heavily bombarded by the Houthis and a 20% drop in value, so that the presentation of a triple value apparently hides cash given to Mr. Meverak due to his involvement. 3.3 In 2021, the young man, who was the banker in the account, was fired from the bank. The mother, who designated the plaintiff for accounting, asked her to follow what was happening at the bank. But on the 21st, after the young man bought a number of bonds, an issue that was of substance, against the background of the increase in interest rates under the conditions of the coronavirus, the young man began to carry out reckless actions of selling companies from the top 5 of the world. Due to the plaintiff's criticism, or against the background of the preparation of the power of attorney document, the young man cut off the right to view that she had and blocked the mother's access to the bank's application. The pair of brothers took over the 2 apps, the actions and the viewing. Along the way, there is a great deal of direction and involvement of Mr. Arik Mevarak, even though by law, he must not have a personal interest. The brothers have a violent background towards the plaintiff and even caused her clinical death in 2015. 3.4 It was claimed that Mr. Arik Mevarak, an attorney, unlawfully drafted an enduring power of attorney for the deceased Hannah Radley 0125043004. The aforementioned made a mistake in court on behalf of the Radley brothers Dan Bartleo dead because she had signed a document, but according to the supervisor of the Guardian General, the power of attorney document was not deposited with the custodian. In other words, there was no notification, not even of other relatives, including the plaintiff. An enduring power of attorney, which is mainly intended to protect the financial assets and the good of the signatory, has become a tool for committing oppression and theft under the guidance of Attorney Mevarak. He demonstrated his involvement in the illegal activity of liquidating her tangible and intangible assets while she was living for the benefit of himself and the couple of brothers, in violation of the law. The following is a detail. 3.4.1 Intangible assets in the deceased's bank. Blocked banking information from the plaintiff and the deceased for 2 years, when the pair of brothers illegally took over the bank app of the sick elderly woman. Hannah Radley's late husband left an investment portfolio that the brothers used for gambling and reset the portfolio as of the end of 22 to the balance left by the deceased on the day of his death. As of the day of liquidation of the assets, around January 24th, 10 million was missing. 3.4.2 Tangible real estate A. The intention was to take over an apartment that was a source of income in Elad. Attorney Mevarak advertised himself by electronic means as a real estate lawyer and demonstrated great involvement and proficiency in real estate proceedings. The deceased had a real estate rental income in Elad, a 3-room apartment. This income was planned by her late husband as an exempt rent, which does not burden the tax brackets. In 2021, the brothers stopped the aforementioned income and turned the apartment into an exclusive vacation for themselves and did not even grant the plaintiff or the mother the right to use the apartment. Practice which was probably based on a forged pre-estate document. The attempt to sell the elderly woman's home while she was still alive was involved in planning a real estate transaction to sell the mother's house in which she had lived since 1967. In order to describe the cruelty of the move, the circumstances of the case were that the couple of brothers misled the deceased that due to hip replacement surgery, she would experience moving to a nursing home for a week, and if she did not like the place, she would return home. The aforementioned packed her belongings, and a few days after the move they claimed that she could not return home because she had run out of money and they had to sell her home. The plaintiff lived and cared for her mother at home, but the eldest blocked her from visiting, and when she managed to see her mother, she cried because they had expelled her from her home and would not allow her to return. Mr. Meveraka's handprint and involvement are evident when he pressured the plaintiff to be divorced from the mother's shared villa, where she lived and cared for her parents for about 20 years. Attempts at divorce with the mother dying in the background. Forced evacuation from home and the death of a relative are both events which, according to the study, are the most traumatic events that can occur in a person's life. As stated, the aforementioned prepared an enduring power of attorney document for the deceased that was illegal, but he exerted pressure and coercion on her. As if the document was legal and she had no choice but to die in a nursing home in which she did not get along, cut off from her home and garden. The lawyer's involvement in the sale transaction is presented in a negotiation document that took place with the plaintiff about 2 weeks after the mother's death. The plaintiff did not know about the document that was made to her mother behind her back, nor did she know anything about strange wills, according to which her older brother, immature and a chronic gambler in the capital market, and her younger brother, whom she trained both in his bachelor's degree in creating a seminar paper and helping him in his studies in investment consulting, a will according to which they would manage the funds in trust with relatives as an accountant. In the negotiations, Mr. Meverak repeatedly claimed that there was a buyer for the villa. It is important to note that this is 2 weeks after the mother's death. In other words, we were dealing with an active sale process in which he was already involved in the mother's death and was up to date with the details, when in the background, according to the law, as a person who prepares a power of attorney document, he must not have a personal interest in the matter. In order to clarify the cruelty of the real estate transaction on the dying mother's house. As soon as the siblings announced the sale of the house, at this stage there was a significant deterioration in the mother's condition, which led to a chain of anxiety and a variety of autoimmune diseases. The siblings took medical responsibility for her at this stage, while at the same time they held her bank and tried to liquidate her assets. It is likely that this was medical negligence if greed was guiding them. Within a month she could not speak. Her body was deformed without motor ability due to an autoimmune disease of rheumatism, and afterwards, she was diagnosed by a neurologist with muscular dystrophy, another autoimmune disease. It should be noted that her demand to donate her body to Tel Aviv University was not fulfilled, but rather she was buried in a regular burial, and therefore they buried suspicious circumstances for her death, such as the fact that the muscular dystrophy may have been the result of the imposition of opiates by the eldest, he obtained heavy prescriptions and did not return them to a pharmacy in Ichalov, and it should also be noted that after her death, the medical file and the neurologist's findings were stolen. The planning house of the sale of her residence while she was still alive, while exerting pressure on her, as if the document she signed with him was valid while demonstrating proficiency. In addition, the aforementioned instructed the pair of brothers to carry out violent acts against the plaintiff, including physical violence and surprise attacks. 4. The legal arguments. For point 1, the offense of oppression, a criminal offense in which, in the case of an elderly woman in a precarious physical condition and her lack of understanding in the Hebrew language, there is exploitation of distress. Physical weakness in order to receive property and money illegally. This is about the abuse of a helpless elderly woman on the verge of her death. There is strict regulation on the subject of an enduring power of attorney, the guiding principle of which is to protect the financial interests of the appointer. Mr. Meverak went through many pieces of legislation on the subject. 1. Failure to hand over to the custodian general. 2. Misleading the appointer as if the document has legal validity and also initiating inhumane pre-estate actions, while misleading the custodian. 3. Involvement in the theft of the appointer's assets and contributing to the physical deterioration of her condition. 3. A personal interest that must not exist. The seriousness of the offenses of which Mr. Meverak is accused must be emphasized. It was claimed that this was a person who was supposed to make sure that there was a financial envelope that protected an elderly woman in the event of incapacity, but the aforementioned took systematic and continuous advantage of the training given to him. Legal references to the unfair influence of the defendant, Mr. Meverak, on a couple of brothers of the Radley family, while he was trying to obtain material benefits that fit his anti-Zionist worldview. Abundant evidence of the unfair influence of the lawyer in the matter of various legal documents. Enduring power of attorney, which is supposed to be a defense, as in the case of the Atzman judgment. In the minutes of the negotiations, in the appendices, it can be seen that ADV, Meverak, was involved in attempts to sell the mother's house while she was alive. As the deceased claimed, they divorced me. They say they have to sell my home. In Appendix 1 of the transcript of a court case on the subject of a will in which a couple of brothers with no financial education will manage a trust for their sister. The plaintiff fled from the courtroom when she found out that Mr. Meverak had secretly and illegally created this power of attorney document when her lawyer arrived at the courtroom, mourning, after 2 months of fighting in Rafah in reserve service. The honorable judge determined that the will originated in error. It can be read that Mr. Meverak, the defendant, he talks about himself and about the power of attorney that was created for the mother, as if different forces are acting on him and around him in the creation of documents such as legal, wills, power of attorney, which led to the death of the mother. without mentioning the fact that for some reason, he has all these documents. The following is a quote from the minutes of the hearing. The deceased made an enduring power of attorney in which she appointed the two sons, Dan and Oded, as power of attorney. The power of attorney was not activated because she passed away before. Mr. Meverack forgot to mention that he was the one who created the document. He spoke about the initiatives of a woman of Danish descent who speaks English with the family, a mother of 4 children, a housewife with a business as a tour guide who was engaged in guiding tourists from abroad, and it is unlikely that she learned such a legal term and even initiated it. Why a lawyer is involved in too many proceedings with financial benefits that include violence against the elderly. Helpless and Zionist women, their divorce, taking advantage of his knowledge of real estate in digital publications, that is, on the internet. He previously advertised himself as a real estate lawyer. The lawyer argues that all the legal documents, or like legal ones, are the initiatives of people who speak English, new immigrants, which he interprets to him, and it is reasonable to assume that, like the eldest, he also does not speak English. There is a forged medical guardianship document in Ichilov, which may have created a couple of violent thief brothers who abuse their mother and sister and are always busy with it. Will they be medically responsible? The Ginger judgment on food poisoning at a neighbor's house ruled that there was a suspicion of an attempted murder of a lawyer Meverack involved. On whether they tried to force chemicals on the objector, they tried to force chemicals on the objector. That there is a 22% chance of death, and it is clear that since 2016, this is the entire economic plan that Meverack has planned to expel Zionist women from their homes by drug coercion of poisons. The eldest, Dan Radley, after hip replacement surgery, got the mother a pair of opiate boxes and screamed at the mother that she should take it for 2 weeks. The mother was horrified. His wife, who was forced to absorb benzodiazepine poisoning from him, claims that he is an alcoholic. His team in the Golani apparently suffered on his own initiative, while claiming that they were crazy dopamine blockers. It should be noted that the eldest was in prison 6, and the rumors in the Metropolitan Police Department were that the alcoholic had begun to trade cigarettes with Hezbollah with a fear of drug trafficking. And at least 3 of his staff members found themselves on dopamine blockers. Paralyzing and dopamine blockers, which the eldest also forced on the plaintiff, while the eldest took advantage of the KGB veterans who came to Israel in the 1990s, on the orders of a Soviet psychiatrist during the time of communism. The definition of mental disorders, which is a global definition, included a special Stalinist clause. Mental disorder. Opponents of the Diem regime included the freedom of action of the poisoners in the service of the Stalinist regime. That is, the possibility of imposing poisons on opponents of the regime. A pair of brothers who have been dismissed from the IDF and a messianic lawyer are trying to break the law or make baseless claims that a pea-sized girl poses a threat of violence just because she fought for her life and her mother's life, for their right to their bodies and their territory. The fact that the pair of brothers, under the guidance of the lawyer, attribute to an English-speaking couple, i.e., to the deceased Redley Hannah and to the deceased Redley Howard. Initiatives in the creation of legal documents that are in the possession of the defendant, and as a result, contrary to the wishes of the deceased, Mr. Meverack directed them as follows to carry out with the mother's body after her death. To refrain from presenting the ADI card to prevent the donation of the mother's body for an autopsy at Tel Aviv University, and afterwards to carry out surprise attacks on the house. These include the theft of the mother's medical file, the deprivation of financial information from the plaintiff. 5. The damage. 5.1. This is a violation of the elderly woman's individual rights and participation in physical and economic violence against the plaintiff. The plaintiff suffered terrible grief and pain due to her late mother's treatment and oppression, which includes a change in her lifestyle, exposure to suffering, causing harm to her, an increase in the level of risk that existed around her, and a real harm to the safety and security of the elderly woman. One of the laws enacted in order to prevent elder abuse is the appointment of a guardian under the legal capacity and guardian law. A law intended to protect was used as a pretext and a pressure hammer for the purpose of abuse. In addition, the plaintiff was abused and violent during and after the mother's death while he was trying to sell the elderly woman's home for the purpose of selling real estate. The economic damage caused for which compensation is required, details of the damage and the economic compensation. As part of the illegal power of attorney prepared by the defendant Meverack and on the basis of which the brothers took over the deceased mother's banks and tried to sell the deceased's house while she was still alive, while isolating her from her friends, and in the mother's words, "They kicked me out of the house. They say they need the money." As part of this illegal activity, it was claimed that the defendant was transferred to the defendant Meverack in the amount of $1 million. Promises to the partnership regarding the sale of valuable real estate, $20 million. Or that a sum of $1 million was transferred in cash to Mr. Meverack. Mr. Meverack has denied the plaintiff access to current account and credit card transactions for 2 years on the grounds that the young man is a banker in the mother's account. Promises in cash/cash equivalents/ loss of 2-year self-exempt rental income if about NIS 5,100 per month, i.e. NIS 144,000. There was criminal negligence in taking care of the mother's health after hip replacement surgery. Under Mr. Meverack's guidance, they refrained from obtaining help at home. The plaintiff was forced to resign from a senior position at #1 accounting firm in the world and to take care of the mother. This is a salary of approximately NIS 16,000, approximately NIS 144,000 for 9 months. In addition, against the background of the abuse and violence that occurred against the plaintiff detailed in Section C, The aforementioned lost clients in the independent case in the field of relocation taxation in the amount of approximately NIS 40,000. Total loss of income in the amount of approximately NIS 184,000. Attorney Meverak advertised himself electronically as a real estate lawyer. In addition to damaging the deceased's long-standing rental source in Aylot, he was involved in planning a real estate transaction for the sale of the mother's house, in which she had lived since 1967. Against the background of his attempt to sell the real estate, apparently for liquidation, there were threats against both the plaintiff and threats to dismantle the house in which she lived. Agents were sent who damaged the plumbing. They hit the chimney so that the ceiling cracked and a pole fell on the plaintiff. The total damages are about 300,000 NIS. Medical and legal expenses, mental anguish, pain and suffering, and bodily injuries, about NIS 300,000. The plaintiff paid the negotiators about NIS 55,000. Negotiations in which she agreed to leave the house that her mother had built for her in exchange for not handing over the will, which Mr. Meverak stored in his drawer, and which the plaintiff did not know existed. In the negotiations, Mr. Meverak revealed that a real estate sale deal already existed, while refraining from revealing what happened in the banks for 2 years. Mr. Meverak sent the brothers to beat the plaintiff, to send death threats, emissaries who walked through her residence at night and broke the building. She was forced to seek treatment for a group of battered women due to the fact that Mr. Meverak sent the pair of brothers and their agents to harm the plaintiff. She was forced to seek treatment in a sleep and hypnosis laboratory due to insomnia of the surprise attacks on her residence. During this period, they attacked with dozens of text messages threatening murder, dragged and punched a body, carried out surprise attacks, and sent emissaries at night to attack. The plaintiff suffered from insomnia for a long time. Bruises on her body left dermatological scars. She had to seek psychological treatment and lost her livelihood. Appendices. In Appendix A, Mr. Meverak's testimony is that he created a power of attorney document and that he was registered with the Bar Association as a certified person. Mr. Meverak argued in court that the power of attorney document was created out of thin air and did not mention his involvement. Appendix B encloses correspondence with the Guardian Supervision Unit. According to the correspondence, the power of attorney was not deposited with the Custodian General, but as far as the lawyer and the brothers were concerned, it constituted a valid document in which the mother was pressured to give up her assets. In Appendix C, this includes negotiations to evict the plaintiff from her home about 2 weeks after the mother's death. Negotiations, initiated by the plaintiff after the beatings, sent a sapper named Kobe Cohen to create deliberate sleep torture at night while breaking a pipe and deliberately opening a chimney, so that the house would collapse on the plaintiff while she was alive. Mr. Meverak's active involvement and personal interest in the liquidation of the assets is evident, while depriving Zionist women of their lives. In the negotiations, Mr. Arik declares that the brothers already have a buyer and they need the money. Mr. Eric pressed for the sale of the mother's house while she was still alive, so that it is reasonable to assume that he knew the buyer and denied the plaintiff the right to know. In Appendix D, a summary of financial and banking information prior to the brothers' takeover, a sample from the investment portfolio chosen by the deceased father. A British and Israeli citizen who served in the IDF until the age of 53 and chose to retire from his military service only when he was forced to go out alone in the gas unit during the Gulf War to sample chemical toxins, as well as a sample of credit card expenses, etc. Balances that were sent to the house after the brothers took over under the direction of Mr. Meverak are presented. The court seeks to compel the bank to provide details of transactions. Auditradley, the younger brother, was an account banker for about 15 years. Appendix E, documentation of physical violence and sending saboteurs at night. Appendix A is a photo from the minutes of the hearing in the case of 25135-06-24. The picture is marked in color with Meveraka's declaration of an enduring power of attorney for the mother, which was created out of thin air. Power of attorney, which is doubtful whether an elderly English-speaking woman-initiated Appendix B, picture of correspondence by email, correspondence, response to the custodian general and the supervisor of the custodian. Dana is a lawyer in the supervisor of the guardian about the non-deposit of the power of attorney to the custodian general. That is, the lawyer created an illegal document. Such a document was not deposited by attorney Arik Meverak, a regulation intended to protect the elderly. The deceased was misled under his direction. Appendix C, a quote from a lawyer who created an illegal power of attorney, attesting that he was involved in a real estate transaction for the sale of the deceased's house while she was still alive. Appendix D, a summary of financial and banking information up to 2020 from a complaint to the supervisor of banks and the Israel police. Prior to the brothers' takeover under the deception of an enduring power of attorney document created by Mr. Meverak. The plaintiff served as a tax consultant and accountant for most of the family for many years, as well as for the mother. The following is the summary budget of the expenses she managed for the mother. For years, the deceased's total annual expenses amounted to only about NIS 75,000. Since 2021, it has been suspected that the pair of brothers, against the background of Mr. Arik's document, withdrew from her account. We will admit that the court will allow the disclosure of the information that Mr. Meverak and the pair of brothers are hiding regarding the years 21, 22, and 23. The following is a summary of my expenses compared to the late Hannah Radley. The following is a picture of reports to the authorities on the income of exempt rent that was used by the deceased couple for many years in Elad as a result of tax planning. Below is a picture from the deceased father's investment portfolio, There is an Excel sheet from the date of the father's death, which the deceased mother asked her daughter to check and take a look at what is happening in the bank. Since 2021, the brothers have prevented the defendant from disclosing bank information, despite the fact that the deceased couple financed and pushed the plaintiff a screenshot of a computer AI-generated content may be incorrect. Appendix E, documentation of violence against the elderly woman's wishes and violence and sending sappers to the plaintiff. Below is a photograph of the deceased's request to donate her body to science. The pair of brothers who took the trouble to rob her for 2 years stole her medical file after her death and also buried her without an autopsy against her will.
הצהרת אורי אוינפלד על כניסות חבלן.
Documentation from a restraining order file by attorney from the Forensic Medicine Orion Benhai. The requested remedies. In light of the above, the Honorable Court is requested. 6.1. To obligate the defendant to pay the plaintiff a refund of the amount of the oppression and compensation in the sum of $2,231,901. 6.2. To compel you Bank Rothschild branch to disclose banking information against the background of the illegal activity that took place, the banker, a friend of the younger brother, claims that only a judge can compel him to present the information. In an application to the supervisor of banks, the supervisor recommended suing the bank for concealing information. We will ask that the bank be required to present all credit transactions, investment portfolio, and current account for the years 21, 22, and 23. In light of the mother's complaints about their takeover of her card and the bank balances that were sent to the residence, we would like to clarify holes, including large cash withdrawals given to Mr. Meverak. 6.3. To charge the defendant with legal expenses and attorney's fees plus VAT in accordance with the law. Authority. 7.1. This honorable court has the substantive and local jurisdiction to hear the claim. Therefore, the honorable court is requested to summon the defendant to trial and to order as requested in this statement of claim. Appendices. Transcript of a hearing with a declaration of power of attorney. Correspondence with the supervisor of the guardian. Non-deposit. Negotiations. Mr. Meverak declares that there is a buyer for the villa. April 22nd, 25. Tax Consultant Rudley Nina.
מספר אסמכתה למעקב 25839897. הדפסת אסמכתה על ההגשה.